And so we've been friends ever since. He's also a PhD in chemistry. Oh, Jim is a PhD in one of those bio thingies that nobody cares about. But Dave is a real scientist because he's a PhD chemist. And so Dave and I have worked together at a couple of different companies. And right now we're in the process of launching a startup company in the dermatology space. So exciting stuff. Dave is not a lawyer, but he's had to basically develop the IP strategy for the companies he's been with, including, more importantly for today, figuring out how to protect the company's trade secrets and then convincing everybody else in the company that the trade secrets need to be protected. The hand raising is.
There we
Hi,
go.
Dave.
Hi. Sorry, I lost track of my mute button, but
Okay.
thanks for the introduction. And it was Sam and I, as he said, did a lot of IP development in a startup company environment, and it was very exciting work to do.
Very good. So I have the hand raising is on. Everybody who wants to come on stage, please raise your hands. Come on up so we can get a conversation going. It's not just going to be me or us lecturing with questions and everything. So once the formal presentation is over, we'll open up the room to all conversations. The slides for today, the link is on top, and so please click on that. If you have trouble opening it, let me know. I will refer to slide numbers. Those are there's no slide number written on any of the slides. It's just the number of slide in the deck that I refer to. So slide number 1 is just the title slide, and we go to slide number 2. So these are, we've seen this slide many times before, and so usually we always, let me, for Jim and Dave's benefit, the talks that I'm giving now is a modified version of the intellectual property survey class that I teach at University of Utah. So a lot of the how I set things up, etc., are for law students, but I've modified them for a general audience, hopefully in a way that's understandable and accessible to people who have not gone through 2 years of law school. This is a third year of law school class that students take, so they already have quite a bit of background in law and how to interpret law and what certain keywords mean, etc. So I'll try to point those out.
Can I
So
just say something, Sam?
please.
Just for the record, we are live on YouTube on the Scientific Discourse channel. You can watch live if you follow the link in chat, or watch it again later on when the episode here is over.
Thank you, Shamash. Okay, so on slide 2, we have elements of a trade secret. What is the information? What do we need to have a trade secret? We said that trade secret is an information that first the holder of the trade secret derives an independent economic value from the fact that information is a secret. Trade secret is not generally known and is not readily ascertainable. Last time we went in detail about what ready ascertainability means, and we said that if you need to really spend any time, money, effort into trying to ascertain the information, then that information is not readily ascertainable. And we saw that the court said something that's readily ascertainable is something that can easily be found in a journal article, in in a magazine, in something like that. So I don't know if Jim agrees with me or not, but I usually say if you do a Google search and it shows up in the first 2 or 3 pages of your search, is readily ascertainable. But after that, you run into issues of whether it is readily ascertainable.
Shockingly, I agree.
Okay, very good. That's one for the team. And then the information needs to be obtained by proper means. We also talked about what improper means were. Those are not necessarily illegal means, but they're means that are not proper. You cheat, lie, deceive, etc. to obtain the information. And that the information has to be subject to reasonable efforts to maintain its secrecy. And we saw that most litigation in this case, in these cases, happen on the last 3 elements: whether the information was readily ascertainable, whether the defendant, the one who's accused of stealing the trade secrets, used improper means, and whether the plaintiff, the person who's trying to enforce its trade secrets rights, used reasonable efforts to maintain its secrecy. So today, we're going to talk about reasonable efforts. Any questions before we start? Any comments? All right. So, slide 3, we're going to talk about DuPont v. Christopher. This is a very famous case, but it is a very short case. And it is a case that, if you're familiar with trade secret analysis that happens today, the case is not going to make much sense to you, because the court in this case doesn't go through a typical trade secret analysis, mostly because at the time the court wrote this decision, there was no normal trade secret analysis. And Uniform Trade Secrets Act that we've been talking about, and we showed the elements of the trade secret, etc., that comes from UTSA, basically used the analysis of DuPont v. Christopher to come up with a lot of the provisions in the Act. So even though this case is not your typical trade secret case, it is the birthplace of a typical trade secret case. So we always, kind of when we do a trade secret study, at some point, usually pretty early on, we get to DuPont v. Christopher. So what was happening in the case of DuPont v. Christopher? On slide 4, we have the facts of the case. DuPont was building a chemical plant in Texas. So first of all, everybody should know that DuPont is a major chemical company in the United States. It is based in Wilmington, Delaware. It was founded by this French nobleman in the 18th century, E.I. Dupont de Nemours. And today his heirs are still around, and they own a majority share in the company. Pierre Dupont, one of his great-grandchildren, was the governor of Delaware in the 80s. Anyway, so that's DuPont. And DuPont started out by making gunpowder. So it was mixing sulfur and saltpeter and other things that go into gunpowder. And so there are some interesting architectural sites on the DuPont site in Wilmington for where they had the gunpowder mixing rooms. they only have 3 sides, so they have 3 walls and a roof. And the open side opens towards the Delaware River. It's on the shores of the river. And the reason is that when, not if, but when the gunpowder blows up as the person is mixing it, it's not going to cause any structural damage because the force of the explosion goes out the empty side into the river, and so the walls and the ceiling remain intact, and the only casualty is the poor bastard who was mixing the gunpowder. So that's the story of DuPont. DuPont was building this plant in the late 1960s in Texas. This was a new process that DuPont had developed for synthesizing methanol, which is one of the biggest industrial starting materials. And the process was such that if you showed where all the towers and pipes and valves and this and that were to a chemical engineer, the chemical engineer would be able to immediately figure out what the process is based on the design. Christophers were hired by a third party, which throughout the litigation, they never revealed who that third party was. And they basically took all the brunt of the case. I don't know if there was some secret deal in the back. There probably was, but we don't know about that. Christophers are 2 brothers who are pilots, and they do aerial photography. So they're hired to fly over this plant and take aerial pictures for their client. DuPont personnel see the airplane flying, and they get in a car, chase them to the landing strip, and get their information and sue them for claiming misappropriation of trade secrets. That when I say they claim that with today's language, it would be called misappropriation of trade secrets, even though the court doesn't say that. So we go to slide 5, and so, well, what are the issues here? See that there are 2 issues. One is, did the Christophers use improper means to obtain the photographs? And the second one was, did DuPont use reasonable efforts to protect its secret? The first question is, the answer is no. Flying over an area and taking pictures of it is not illegal. Aerial photographers do it all the time. And so we also know that in the Fourth Amendment illegal searches and seizures case law, the police can fly over your property and take as many pictures as they want, and that is not an illegal search. They don't need a warrant to do that, because the argument is that as you're flying over, this thing doesn't have a roof, it's open, so it's visible to everyone. You can take a picture. You haven't done anything illegal. So improper means was not used in this area. But did DuPont use reasonable efforts to protect its secrecy? So they knew that aerial photography is possible, but they didn't put any barriers over this thing to prevent aerial photography. So that becomes a big question in the case, whether DuPont used reasonable efforts. So in answering that question, I'm not going to strictly talk about what the Christopher court said. I'm bringing in decisions from other courts in this area, because so usually in a law school class we start with Christopher and then case after case after case. we bring it down to the current analysis that the courts do. I'm going to spare you that and just go directly to the current conclusion of how the Christopher case would be treated by the courts today. So the courts say that in an extreme case, can what is a reasonable precaution be determined on a motion for summary judgment? So Christopher and other cases in this area have come up on a summary judgment motion. Summary judgment means that when all the facts are taken for the benefit of the non-moving party, you see that there is really no factual dispute between the two parties, and so the case can be decided as a matter of law by the judge. It doesn't need to go to the jury to decide the facts of the case. But whenever you have the word reasonable in a legal analysis, you know immediately that summary judgment is going to be very difficult. Because what does reasonable mean? Reasonable changes based on the standards of the community, whether that community is the nation, is the state, is the city. It's in a particular cultural or time period. Reasonableness changes. And so when we have words like this that are subjective, that we don't know objectively what reasonable is, then the jury has to decide the reasonableness of an action, not the court. And so summary judgment is not proper there. But so why the reason that summary judgment is not proper is not important. Why is it improper becomes important is that no, the fact that it's improper is not important. Why it is improper is important, and that's it. Because the answer depends on balancing of costs and benefits that will vary from case to case and so require estimation and measurement by persons knowledgeable in the particular field. So what is reasonable has to be decided on a case-by-case basis depending on what the situation is. So this is not like the criminal case where flyovers are always okay. Here, depending on the case, flyover may be okay, may not be okay. A jury has to decide that. So we go to slide 7 and we see what are some of the incentives, what are some of the things that we have to look in at. And it says, if trade secrets are protected only if their owners take extravagant productivity impairing measures to maintain their secrecy, the incentive to invest resources in discovering more efficient methods of production will be reduced. So basically what it says, if we demand that corporations take the same measures to protect their privacy as a criminal defendant does, that is really make sure that your information is secret and the police cannot get there without a proper warrant, if you have to take those kinds of actions, that's going to be wasted money. That is a money that's going to go into prevention measures, and those prevention measures are not economically productive. They don't go into the improvement or the production and the marketing of the product. So yes, basically we will ask the trade secret owner to take some measures, but we're not going to ask them to take measures that would make the protection of the trade secret completely waterproof, that nothing will penetrate. Because if we do that, then we're going to kill business. And we do recognize that patent protection is costly and temporary, and so for many of the companies that we deal with, trade secret protection is the proper way of protecting your intellectual property. I think Dave and I will have a conversation about this at the end, about protecting the trade secrets of one of the companies he worked at, and why we didn't decide to go a patent way. We decided to go trade secret way. So conclusion of this case is on 8, and we come up with 2 concepts of trade secret protection and misappropriation. These 2 concepts, these 2 different regimes for protection, come from the 2 requirements in the law. One is that the defendant should not use improper means, and the other one is that the plaintiff should use reasonable efforts. Those protect 2 different things. The first one, where the defendant has used improper means, trade secret misappropriation provides a remedy for an independent legal wrong. So the theft is an independently legal wrong, regardless of whether the information was a trade secret or not. Theft of the information is wrong. Cheating an employee to give you the information is an independent legal wrong. So the bad acts of the defendant, and those bad acts are defined as independent legal wrongs, they are the ones that basically make us do things to protect our trade secrets. So we're going to do that to deter efforts for their taking. Well, why is it that we don't want people to just take somebody's trade secrets? Because when you illegally or improperly take somebody's trade secrets, what you have done is you have redistributed the wealth from the trade secret owner to the trade secret stealer, and that is not an economically productive redistribution of wealth. And taking trade secrets using improper means, the sole purpose of it is to do that redistribution of wealth. And so we're trying to stop that, because we say that the plaintiff, the trade secret holder, is the party that can best take advantage of that trade secret in order to bring the product to the market. So we're going to protect that against bad acts. The second one is that nobody's doing anything wrong, right? But the information that we have is so valuable that even though nobody's doing anything that is legally wrong, we still say that their actions are wrong in order to protect that highly socially valuable information. So we with reasonable efforts, by having reasonable efforts, we're saying that even if the defendant is using non-trespassory, that is, they're not invading your property without permission, or other unlawful acts. So even if it's non-trespassory or lawful, we would still find liability because that information is so important. So in this case, we see that there was no independent legal wrong. Flying over and taking pictures is not in and of itself necessarily a wrong act. However, the value of the information is so high that we're saying that we're going to prevent you from engaging in this legal act for the sole purpose of that economic productivity purpose. That we're encouraging inventive activity by protecting its fruits from efforts at appropriation that are indeed sterile, wealth redistributive, not productive activities. So if I come and I steal the information from you, I have not engaged in an economically productive activity. Instead, I have done a sterile wealth redistributive act. Questions? Jim, you should have some comments at least.
Wow, it's like you read my mind. Okay, so one of the things that you said, well, a couple of things, step back. And you may have already covered this in earlier lectures, but I'm wondering if you might think it relevant to discuss the role of intellectual property law and how it incentivizes innovation. And in this particular aspect, providing a vehicle to protect trade secret is a way of encouraging innovation.
We have talked about this, but the fact that we have talked about it doesn't mean anything in these lecture series because it's not always the same group of people who come here. So why don't you tell us about that? That I think is a really good topic of conversation that I would like to have as many times as possible, especially since patents will start next week. And that is where we see this effect of IP law and economy the greatest. So would you like to tell us about that?
Sure, I'll be very brief just because A, I have another question, but they're related. And B, I don't want to steal your thunder for next time. But at least with respect to patent law, is how I'll tee it up. There's a quid pro quo built into the Constitution of the United States where the government, the state, has created a system by which it incentivizes innovation through the possibility of a monopoly for a limited period of time, a patent, in exchange for the complete disclosure of the innovation in such detail and in the level of detail that would allow society to practice that innovation once the monopoly has lapsed. So more simply put, the government will give you a patent to allow you to exploit your innovation. And in exchange, once that patent expires, then you dedicate that invention to the public and anybody can use it. Trade secret is different in that uh, it can create a right that, in theory, can last forever, as Sam said earlier, the Coke recipe, the Coca-Cola recipe. But it is the weakest form of protection of intellectual property because if there's an inadvertent disclosure, if somebody figures it out for themselves, then your intellectual property right in that trade secret evaporates. So Sam's discourse on that case was making me think about, well, where are the incentives here? We want people to bring products to market. We want people to innovate, and we want them to be able to exploit them to a reasonable extent. And trade secret is a means by which to do that. Uh, So that was my line of thinking. Sam, do you want to add anything to that before I go to my next question?
Yeah, I don't think you closed the loop on that, which
Okay.
is, so how is it that if I protect my intellectual property and not share it with anybody else,
Mhm.
how is it that that will incentivize invention and economic activity and advancement of science?
Well, it doesn't advance science because science basically, on a fundamental level, is a discourse and an interaction of different folks working on the same problem and coming to solutions and sharing that information. So it doesn't advance science, but trade secret can advance economic the economic interests of the person who comes up with the trade secret. It incentivizes bringing products to market for profit.
So I'm going to add to that, and I would
Please.
say, if I'm doing something that's economically advantageous and I'm making money off of that and I'm bringing to the market a product that the market wants, everybody else wants to do what I'm doing because they also want to have a share of that pie.
Right.
But they can't because I have an IP on the product, method of product, etc. I have IP that would prevent others from developing that product for themselves. And so if I want to do what the IP owner is doing, then I have to come up with a new inventive way of achieving the same result, or maybe even better results. So I can destroy that first one in a competitive market because my product is better.
Mhm.
So IP would allow me to work very hard and inventively and creatively to get around that person's IP.
What kind of IP are you talking about?
Any kind of IP.
Say that.
Trademarks, no, but the other three, I still have a fundamental philosophical problem with trademarks being IP, but we're not going to discuss that or resolve it here. So copyrights, trade secrets, and patents, because these are exclusive rights on the ideas and expression of ideas. So if I want to have a new idea or a new way of expressing that, then I would have to get around the IP holders' intellectual property.
So
And
let me interrupt you for a second. So I agree with you 100% if the IP, quote unquote, that you hold is a patent. But if
no,
the IP that you hold is trade secret, I see you make a widget. I
wrong.
see you, let me finish. I see you make a widget. I see you market said widget. I see you making money hand over fist. I take that widget, I reverse engineer said widget, and then I start making my own widgets. I have not violated trade secret law, and I have destroyed your intellectual property.
If
If I do the
I
same,
if
I'm sorry,
I
let me make one final point. I beg your pardon. If you have a patent on the widget and I reverse engineer the widget and then I make the widget, and let's assume you have method claims as well as composition matter claims, and it's exactly the same thing, and I'm using your method, then I have not destroyed your intellectual property, and you're going to sue me into next week.
no, because
Yes.
because if if you have a trade secret, right?
Uh-huh.
I'm gonna sit here and I say, I really want to do what that guy's doing. How is he doing it? How is he doing it? And so, what am I gonna do? I'm gonna reverse engineer it and copy you. What have I done? What would incentivize me to reverse engineer your product and bring it to the market.
I can
What
make it
incentive?
cheaper. I can make money off of it.
Exactly.
Yes.
Yes. You can make it cheaper. You can make it better. You can make it right. And
I can,
so
or I, go on.
so if you didn't have that trade secret, I would have just copied you, and I would have right. But because you have that, and because I can't copy you, then what I do is that, and I want to do that, I have to reverse engineer it. And
Uh-huh.
the only way that would make sense for me to come to the market if is my product is somehow superior to yours. Either
Or
it's
or
cheaper or it's better.
or you engage in uh, competitive practices that in the short run are not logical, but in the long run will eliminate the competition. You
Or
sell
you
at a
do
loss.
that. Or
Go.
or you do that. But we're assuming a permanently competitive market, right? Because
You're
I
assuming
mean
that.
non-competitive practices have their own legal jurisprudence to deal with.
At
The
least allegedly.
non-competitive. I mean, we have antitrust laws. We have the torts of interference with contracts and interference with business practice. Right? We have a whole bunch of other legal schemes to deal with non-competitive practices when you're trying to non in a non IP way push the competitor out. So
And
we're
do you?
only go
I'm
ahead.
sorry. So that's fine in a perfect world and in an academic setting, but in reality, those those mechanisms aren't foolproof. See Microsoft.
In reality, you're dealing with in every case you're dealing with 4 or 5 different legal theories and legal schemes
Hmm.
that they all come into play. So
I have
here you
a
say,
comment that
okay,
I
in
collected.
this particular case, trade secrets didn't help me much, but anti-competitive laws will help me more. So you do have a huge toolbox in real life, but today we're just discussing the tools by themselves.
Okay. Sounds like
Dave?
Dave wants to say something. Yeah.
I have a. Can you guys hear me?
Yep.
I can tell you guys work together.
We had a lot of these conversations at 2 in the morning.
I mean, there is a certain reality between, from my point of view as a scientist and someone who's trying to protect the value of our company. I have certain things that are patents that investors see value in, and I may or may not have the means to protect my patents. And so I may make the decision not to patent something because I really can't afford to broadcast what I'm doing to all my competitors because they could just quickly copy something of mine that I spent 10 years developing and I put all my money into my development costs and I have $7 for legal fees. So I may decide to, because of resource and competition, to keep something hush hush if I can. And the flying over and taking pictures thing made me think of line of sight. Like if you can see something, does that mean it's public? If you look in someone's window and you see their everlasting golf stopper machine, now you know how to make it. Or if you had an everlasting golf stopper, you could reverse engineer it. Or or maybe there's something in your process, a, a secret way of mixing things to get a very specific long chain molecule without branching to come out the other end. Um, but the finished product has no indication of how it was made. So if somebody else does it, you can't prove that they're using your secret method because there hasn't been deposited in the product uh, a secret how to formula. by, oh, I can see they've got certain branch compounds. He must have used the Tahmassebi method to make that. It was the only way to do this, you know. And so if you can't create something that you can definitively say was made by a specific process, then you might say, I'm going to keep this a trade secret because I have no way of protecting it. I just thought I'd mention that aspect of it.
So that's a very, very important point. And we have many examples in the market, two extremely famous ones, where the product owner decided not to file for patents and instead go the trade secret way. And that decision ended up being an extremely successful decision for the company. First one is Coca-Cola, where the Coke formula is a trade secret. And we do see other competitors in the market, namely Pepsi Cola, RC Cola, Crush, etc., that have tried to mimic the Coke formula. And really, they have had their own various levels of success and competition in the market, but no one is like Coke. No one is like Pepsi, right? They are unique, and so if you want to, this is kind of the argument that Jim and I were having. If you want to come in now with a soda to get a share of that market, you have to come up with your own formula. You have to come up with a formula that people like, that's refreshing, that's interesting, that this, that, and is not the Coke formula. So what have you done? You have basically increased economic activity. You have engaged in innovation. You're bringing additional products for the consumer to the market. You're giving the consumer choice, and you're driving the price of the product down. So this is the good that the Coke trade secret is doing to the marketplace.
You've incentivized innovation because combination of the trade secrets, it's unassailable, and there's a demand for new things because Coke and Pepsi, as you said, have completely saturated the market.
Yes, exactly. And so there's some things you can't patent. There's some things you do patent. And there's some things you can patent, but you don't. You keep as trade secrets. So what do you look at? You look to see how easily reverse engineerable this product is once I put it in the market. Coke formula is not easily reverse engineerable because, that thing at the end that says, natural flavors and natural colors. Good luck figuring out what those are. Right? You can't just inject it into an HPLC or a GC and then that tells you what peaks you have, because they're specifically using compounds that are not separable by chromatography, are not uniquely identifiable by separation means that we have. So you can do that. WD-40 is another product that is very, very successfully being protected by trade secrets. WD-40 is a mixture of various oils, of various chain lengths of the carbon chain. And so WD-40 has contractors that make different parts of this. Each contractor makes it under a different product number. So two different contractors don't know just by looking at their invoices, etc., that they're making the same thing. And then they all send it to WD-40. There are only 2 or 3 people in WD-40 who know exactly what percent of what of these component goes into the final product. And because these are all oils of near enough chain lengths, you can't using our current techniques figure out what's in it. So that is so if you have that kind of product that is not reverse engineerable, then I would say trade secret is a very very good way of protecting it. Any other questions, conversations before we move on?
One more. And you mentioned this offhanded, and it could be just an offhanded comment, but what if you have a situation where, let's go back to my widget analogy, where you have the trade secret, you have the widget. Because I'm smarter and better looking, I can make the same widget better, stronger, faster, but I need your basis to get going. Why shouldn't I be able to acquire that trade secret by any means necessary? Because you said the person who develops the technology is the person who's best suited to bring it to market.
Most of the time, not all
Okay.
of the time.
All right. So you're just, all right. I'll let you go.
Yeah.
Hey, Sam, I got a question for you on the WD-40 or Coke. What if I made a cola product and the HPLC chromatogram of my product and Coke looked identical?
So, yeah, that's what I was. I forgot to address that part of your comments. So, say that again.
I'm just saying, say I make a cola and it tastes just like Coke, and Coke freaks out, and
Okay.
they get a chromatogram. Now they don't have the exact ingredients list, but they've got a, 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 a fingerprint of it, and the fingerprints match.
So then the question is, you filed a lawsuit, and you would say, based on this, there's a high probability that they're stealing my trade secrets. Now, whether that kind of lawsuit can be filed in a federal court that requires specific claiming or specific pleading, I don't know, but definitely you can do that in a state court. And then during discovery, you ask them, how did you come up with this formula? And they say, we came up with it on our own. And they're like, all right, show us your lab notebooks. Show us the process by way of which you figured this out. And so if during discovery then you figure out how they did it and whether they misappropriated your trade secrets or not.
So what if I got 1,000 people who have been drinking Coke for the last 80 years, and they are Coke experts. They come from all walks of life, and they love Coke. They hate Pepsi. They have to have their Coke. They know the flavor of Coke down to a T. And I prepare a myriad of formulations and say, tell me which one of these tastes like Coke. And they're like, this one, I can't tell the difference.
Wouldn't that
then
create market confusion in the consumer, though? So
no,
that's a
well,
whole other
that's
issue.
irrelevant. So in
I
that
guess
case,
just before you go on, the my experience with trying to keep something a secret is, what are the mechanisms? You have to do kind of a risk analysis on all the mechanisms that the secret could be let loose.
absolutely.
And one is, having badging at your door so you know who comes and goes from your facility. Another one is tinting windows. Another one is not telling the secret. Another one is don't give tours from people. Another one is, careful who you hire, because once you teach them what you know, then they know it. So
So these are all reasonable efforts to maintain the secrecy
yeah,
of your information. So now let's say, despite your reasonable efforts to maintain the secrecy, and through no improper means, the defendant came up with your Coke formula, right? And the answer then is, congratulations, you have successfully reverse engineered a trade secret. And that right there is the problem with trade secrets, right? That once it goes out, it's going to be very difficult for you to control it, because let's say I reverse engineer it, but I also cheat and lie and deceive, and I get the information, I put it on the internet. Yes, I'm liable, but the 500 million other people who now have
yeah.
access to this information, they're not liable anymore.
Well,
So your
and
secret's out. You're dead.
on the
So
on the on the owner of the trade secret, Coca-Cola, do they have to prove that formulation is the same as theirs?
yes,
And then they might not want to do that.
yes.
I
So
love that part of it. That's my favorite part of this whole thing, Sam. It's like it's not worth it going to court because then people will be able to know that
exactly,
you lost.
yes. So
But hold up here. So if I'm the competitor of Coke and I came up with the new better or identical Coke than theirs, I have to go to court and I have to defend myself by proving, okay, this is my method, this is how we did it, these are the lab records. Doesn't that reveal my trade? Don't I have the right for a trade secret as well?
no. As a defendant, if the plaintiff hasn't been able to prove their case in chief, then you don't have to present anything. So the first thing that happens is that Coke has to prove that the formula was a trade secret. Then it has to prove that the information got out through improper means. And it has to prove that information got out despite the reasonable efforts to maintain its secrecy. If you can successfully challenge any of these, then there was no trade secret, and nobody has misappropriated the trade secret. So the defendant doesn't necessarily have to say what it is that they were doing. They have to show that what the plaintiff was doing was wrong.
All right, got it.
So it's more dangerous for the plaintiff than for the defendant. And so this is why most innovations, Jim, would you agree with me or not? Most innovations are protected by patents.
Sorry, I was away from my phone. Most innovation, yes. I mean, yes, yes.
Most marketable innovations, because we do get gazillions innovations in the companies and don't see the light of day and they're kept
Yeah.
as trade secrets. But most marketable innovations have a patent associated with it.
Yes, and for a variety of reasons, I think that's true. So in the biotechnology space, for example, and I'll include its ugly stepbrother, the small molecule space, if you're looking for investment the people who have the money that you want are going to demand a patent portfolio.
Yeah.
If you are relying on trade secret, the likelihood of you being able to um, acquire innovation is so much lower because the protection is so much less enforceable or
I
usable.
absolutely agree with that.
Okay, but here's a weird thing for in particular my company, filing a provisional patent. Not a great idea at this point unless we're ready to accelerate in the marketplace. So just declaring that, hey, everybody, here's our thing. Here's our little safeguarded patent portfolio. We were advised against that. We were told that, okay, well, unless you can get the quote unquote next round of funding, so to speak, it wasn't worth filing right now. If there's any commentary on that.
That's a question of timing, not a
Yeah.
question of mechanics.
It's
Yeah.
So
a very fact specific question.
Okay,
Depends
okay.
on
Yeah.
what the product is, where you were in the development process, what the competitors were doing. It is not a it's not a one answer fits all. It's a very case by case. You have to look at a whole bunch of
yeah.
factors
So,
to
Yeah,
so
for
But
sure.
Sam,
with that said,
just a quick
that
question
advice is
on.
probably definitely. I'm sorry to talk
Oh,
over you. But with that said, that advice is probably spot on because unless you are, unless you're in the products, unless you're advanced enough in the product cycle, you know what your compound is going to be. Jumping into a provisional patent application is dangerous.
yes.
but if you sense that you're in a race with your competitors, then you want first
That's
to file. Is that correct, Sam?
yep.
Yeah. So what we do is we file a generic provisional, and then we put in enough species limitations to be able to find a combination that in the future, whatever compound you come up with, you can find a combination of all those species to put it together, and then you put in enough prophetic examples to basically say, yeah, all of these species were enabled, so now you can claim priority back to that provisional and get your earlier filing date. As I said, all of these depend on what your research and development track looks like, how fast is it moving, how many competitive leads do you have, where are your competitors in that space, and I think the one factor that if you're a startup will trump every other factor is that what do your investors want? That is going to be the most important question.
Yeah,
Here,
the
here.
term that I found that was most useful for that was find a kind of like a activist investor who cares more about disruption than they care about return. And so that journey started like 4 years ago, and found
Yeah,
one back in
when
March.
you
So
find that person, tell us who he is, because
I think
we're all
actually we
looking
all
for
know him.
that.
We all know him here. So it was surprising to me because he's very philanthropic. So I was like, really? And he's like, yeah, just start a nonprofit and I'll support it through here. And you can do this and don't worry about return. And I'm like, oh my.
Wow.
Hey
So
guys, I gotta
that
go.
is you.
Sam, I'm sorry I have to leave,
No,
but
no,
this has been so enjoyable. I look forward to the next one.
great.
All
Thanks.
right, take care.
And Sam, I'm gonna have to check out too.
Okay, sounds good.
But I really like this. I got work
All right.
to do, you know.
Yeah, I know. You have that FDA stuff to figure out.
That's right.
All right.
All
Okay,
right.
Dave. Thanks a lot for being
Okay.
here.
Bye.
Take care. Okay. Let me see here. Okay, I'm going to kind of talk about one more case. No, I'm not going to do that. I'm going to stop right here because we've talked about a lot of things, and we've talked about for an hour. So let me stop it here, and next week we'll continue our conversation on reasonable efforts, and then once we're done with that, we will start the patent conversation. So come on up, raise your hands. People are on stage. Ask your questions. Hello, Ayman. Welcome.
Hello, Sam. Hello, everyone. Well, very interesting and exciting conversation today. Um, being who I am, I'm working as a business development and product development consultant, and I built a lot of uh, a lot of improvements, or let's say new products based on the market gap and unmet met needs analysis to the market and to be specific more to the competitive market for my clients, obviously. So in that case, this is not a trade secret law breakage. We don't break the trade secret if you are either creating independent this or you have development or independent discovery for specific existing product based on the market analysis. That's definitely not a breach, or you don't break the trade secret law here, because you are building or you are covering a need that is not met yet. So there's couple of other cases that you can do. You can start not from, you don't always obviously invent the wheel. So you start from an existing product. It's not yours basically, but you're adding or removing or customizing. Any customization is not does not consider in the law, in the world, or over the world globally, because I have been working globally actually. So it does not consider legally as a breakage to the trade secret law. That's the one thing that I wanted to highlight today. And I wanted to thank you and everyone been here and left for the conversation. It's been amazing. Keep doing that because everyone needs it. Thank you so much. Over to you, Sam.
Well, thank you very much. I really appreciate that. Yes, what you said was completely correct. If the information that goes into your product development, if all of it is obtained from public sources, then, and that includes the competitor's product on the market. So if you can kind of open up the competitor's product and look to see what's inside of it and all that, then you haven't broken any laws, because you're innovating based on information that's available to the public. And reverse engineering is that. It's kind of figuring out what information is in the public place. So yes, using public information is the best way to go. Plutos, welcome to the stage.
Hey, Sam. Yeah, I caught some of this. I came a little late, but let's see. Oh, I thought of a couple questions. I got some from your partner and the FDA guy. I guess, but maybe a question I was thinking of is, do you think there should be like a broader, public interest or whistleblower exception to trade secret law? Or
I
should
don't
I
know.
rephrase it?
No. Yeah, I had to think about it. The question is very, very clear. So when you sign a non-disclosure agreement, one of the standard provisions that goes into the non-disclosure agreement is that if, in order to defend yourself in a legal proceeding, you need the disclosure of the confidential information, then you're allowed to disclose that confidential information. And so a lot of times the confidential information is disclosed under seal, meaning that only at first only the judge can review it, and then the judge will decide whether that confidential information is relevant enough for it to be shown to the other side. And then that confidential information is shown only to the attorneys of the other side, not to any of
Not the engineers.
not the engineers. In fact, not the CEO, nobody, only the attorneys who are not in-house attorneys, the outside counsel only gets to see that, and then will use that information as narrowly as possible, and the judge always decides whether that was done or not, as narrowly as possible to put together a legal argument. So in those cases, when you're a whistleblower, when you give the information to whatever government agency you give to, that information is given confidentially. So that disclosure doesn't break it is not misappropriation
Doesn't violate
of
the
trade
trade
secrets.
secret itself, yeah.
Right, it doesn't. But then if you are sued or whatever, and then now you have to defend yourself, saying, because they say, hey, you lied, and you say, no, I didn't lie, really, in this document you said this. Well, that document is a trade secret. You will be able to disclose that information in the court or through all these provisions for when a document is under seal. So you could use that information to defend yourself as a whistleblower.
What about that? Makes me think of like inevitable disclosure. You know, do you think that's too sweeping, or do you think like unfairly?
This isn't strictly inevitable disclosure because once you receive the information, it is not inevitable that you will become a whistleblower. Inevitable disclosure, we'll deal with it. It's actually the last slide in this slide deck, or next to the last slide. Inevitable disclosure means that you have certain information by virtue of having worked in that industry in company A, and then company B hires you to do the same thing for them. You will, unbeknownst to yourself, you will inevitably disclose the trade secrets of company A as you're working for company B, because somebody says, hey, we should, I don't know, put a widget over here. And then you know that you guys in company A tried putting a widget over there and it didn't work. What are you going to say? You say, no, that's not going to work. Well, you now disclose the other company's trade secrets.
Even if it makes physics sense. And I think
It,
that's why
well, no,
all the
then
AI and
if you now sit there and basically start from first principles, work out with the engineers to show that it doesn't work, Well, maybe that's inevitable disclosure because you knew what the end result was going to be. It wasn't a
Yeah,
completely
yeah,
objective analysis,
yeah.
or
My question
maybe
is
it
like,
wasn't. That it's a case by case thing. Yeah, you really have to look at the cases. So that's inevitable disclosure. But if you're a whistleblower, no, that's not inevitable because A, you could probably defend yourself without disclosing that information, or B, it's you're not disclosing the trade secret of your ex employer to the new employer. You're disclosing it to defend your legal rights, and so no, that's yeah.
yeah, so just a quick question. So I think that's why the AI engineers are so valuable because everything has been kind of reasoned through like exhaustive experimentation. Oh, that training run didn't work so well. Oh, here's why and so on. And so the companies are trading these specialists like Pokemon cards. It's kind of wild.
This we will review PepsiCo v. Redmond next time. It's the last case in this slide deck. That kind of you'll see that in really hot industries. Right now, AI is a very hot industry. There's a lot of movement of engineers and technical people from one company to another.
And
And
even though they work at different companies, they're all on the same Discord, which is funny.
yeah, it is. And there, trade secret misappropriation becomes so messy that nobody sues for trade secret misappropriation because
Yeah, that's how it
they
feels.
all have misappropriated everybody else's trade secrets. It becomes kind of, I mean, biotech was kind of like that about 20, in the 80s. Biotech was like that. High tech was like that in the 70s and 80s until you start getting established companies like Pfizer and those people, then it becomes less. But still, in the startup industry, I mean, San Diego is like that because San Diego doesn't have a real established biotech company. And so it's kind of it's a cauldron of innovation. People come together and then the bubble bursts and they go back into the soup and go into another
Yeah, after a
company. And
few
so
beers or something at a
you,
cafe, everyone just tends to talk about the problem because
you
they're all frustrated with the
yeah,
same kind
yeah,
of problem,
the
and you
same
actually
thing
figure shit
exactly.
out in the cafe or in the bar. It's amazing how often that happens, Sam.
Absolutely. And the other thing is that, if you've been in that industry for 15 years, you've worked with everybody in that industry because you all have been moving around. And so a couple of years you guys work together. It doesn't matter. So everybody knows everybody. Everybody knows what a trade secret is and nobody gives a shit. Because
Do you,
go ahead.
I was gonna say, do you think trade oh secrets law favors the big incumbent companies at the expense of startups and competition? Yes.
Uh no. No, I actually think that smaller companies, for them, trade secrets is a lot more valuable because more of their information is protected by trade secrets. Big companies file patents early and often. Little companies don't have the funds to do that, and so they file like a giant patent application once, and then they milk that to death. So most of their information is in trade secrets.
And what about like with recent events? Like, do you think IT laws like trade secrets you know need to be updating, for the digital age, like data breaches and remote work.
Yeah. So the thing is that I can't answer that question because I don't know what issues can come up. Usually, what you have to do is kind of wait for lawsuits to be filed. Then people start saying, "Oh, so these are the issues that people are grappling. These are the legal issues that people are grappling with." And then people start commenting until you get like a handful of appellate court decisions, and then the conversation becomes serious. Right now, we really don't have any litigation on AI because it's so new. We have to wait for the technology to mature a little bit before we start seeing litigation. All right. So, any
I was just trying to think of something. So do you think trade secret protections like fit with employee mobility and innovation? I was trying to
Oh,
think of this.
absolutely. I mean, the issue of non-compete agreements is a hot issue always, right? Because different states deal differently. California decided basically non-compete, non-compete. We don't take no non-compete from nobody, and so non-competes in California have to be so narrowly drawn for them to be legal that a lot of people say, fuck it, I'm just not gonna deal with it. And this nature of non-competes between Massachusetts and California, uh, one that, and the other, the technology transfer policies of Harvard and MIT on the one hand, and University of California and Stanford on the other hand, on the other side. This has been the subject of many, 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 many law review articles because in the 1970s, Route 128 in Boston was the hotbed of biotechnology and high technology. And two court cases came out, one in 1980 and one in 1982, which really increased the value of patents, one for biotech, the other one for high-tech inventions. It made the law very clear and very liberal. What happened was that Massachusetts had a really, really strict non-compete law. So companies could tell employees that once they left, they couldn't be employed by a competitor company for some like 5 years. And the law defined a competitor very broadly. Around the same time, California courts decided that non-compete provisions are anti-competitive, they're bad for business, they're this and that. And then Harvard and MIT took a very, very restrictive policy towards their technology transfer, meaning licensing of their patent technology to outside companies. It was very onerous. University of California said, you have a pulse, you have money, you get a license. And so what this did was that by the time 1990 came around, the Bay Area and San Diego had completely surpassed Route 128 in both high tech and biotech. That is Silicon Valley. Had MIT and Harvard taken the UC approach and Stanford approach, and had the legislature in Massachusetts in the mid 70s, or the courts in Massachusetts in the 70s, taken the approach of the courts in California, then Silicon Valley would undoubtedly be in Massachusetts now along Route 128. South San Francisco would not be the primary place for biotech activity in the world. It would have been Boston. So, yeah, when you loosen that kind of trade secret protection, then things take off, right? If you kind of say, all right, inevitable disclosure is okay, then your economy becomes golden. So I know what I said now goes against what Jim and I were talking about in the beginning, that having trade secrets causes an increase in economic activity. And now I said when you share the trade secrets, it makes the economy grow. And this is the difference between an emerging tech industry and an established industry. In an emerging industry like biotech and high tech were in the 80s, you want to have as much shared information as possible, because there's so much creativity going on that everybody should be aware of what everybody else is doing. But once you get to an established one, then no, you need to be able to protect your marketplace. Any other questions? All right. We will say our goodbyes. And I want to play Crazy Woman for our outro song by Magic Slim. So Shamash, what's going on this week with you?
I'm taking a break actually, so no rooms this Wednesday. I actually need the time. I'm studying for a certificate, so I can't spare the time to prepare the room. So we're taking like a summer break from philosophy, and when I can come back, I'll let you know. We're gonna continue doing philosophy Wednesdays. We're just taking a break. On Thursday we have your chemistry room as well, right?
Yeah, we have my chemistry room on Thursday. If you guys there were last week, then I feel sorry for you. It kind of went over everybody's head, and so I haven't scheduled it, but I will as soon as we get off here. So what I'm gonna do, I mean, we talked about nucleophilic substitutions. I'm gonna kind of take a few steps back and go back to the initial definitions and build up from there, because I realized it was unfair of me to expect people to remember chemistry sessions from 2 years ago where we discussed nucleophiles. So I'm going to repeat some of that, especially since I think, except for me, nobody else is the same in the whole thing. So yeah, so we're going to go back, and so hopefully This Thursday, it will be a lot more comprehensible. Thursday at 2 Mountain Time, 1 Pacific, 4 Eastern is the chemistry room. And then John has his Bite of Physics, the universe absent quantum. He is continuing with that.
No, I think this is the title from last time.
Oh, is it? He
Did
hasn't
he tell
changed
you?
that?
Or no, he hasn't
No,
changed
no,
it
no.
yet. But
I'm just looking it up. So
no, this is
basically,
this is the title from last time. So
yeah.
on Friday he will change it. Yeah, I
Okay.
think he will do the music room on Friday, but he's been saying that he's gonna do it for a month, so I'm not
Yeah.
sure.
Anyway, he's gonna do a Bite of Physics on Friday. That starts 9:30 Pacific, 10:30 Mountain, and 12:30 Eastern. I hope to see all of you guys in all of our rooms, and hope to be in all of your rooms. Okay, so I'm going to leave you with Crazy Woman by the late, great Magic Slim. It's 5 minutes and 48 seconds, and the room will end at the end of the song. Have a great afternoon, evening, morning, wherever you are, everybody.